Have you ever felt like your hard work and years of experience suddenly don't matter? Maybe you were passed over for a promotion, or someone suggested you should think about retiring, even though you are doing a great job. If you're 40 or older, this might be age discrimination. The Age Discrimination and Employment Act of 1967 is here to protect you. Let's talk about what this law does and how it can help you. Here's what we'll cover: what protections the Age Discrimination and Employment Act provides to workers 40 and older, how to recognize signs of age discrimination and how your employer might respond if you speak up, and how a lawyer can help you stand up for your rights and make sure you're treated fairly. Please note this video is not meant to give you legal advice. If you think you're dealing with age discrimination, you should talk to a lawyer. They can help you figure out what steps you need to take and what you should or shouldn't do in your situation. Now, imagine this. You've worked hard your whole life and built a career that you're proud of. Then, one day, you're told you're not needed anymore. Not because you're doing a bad job, but because of your age. That's what happened to Dr. Claire Hanley, a 70-year-old radiologist. Her employer replaced her with someone much younger who didn't have her experience. Dr. Hanley stood up for herself, using the Age Discrimination and Employment Act to fight back. You can do the same. Now let's talk about what the Age Discrimination and Employment Act protects. The Age Discrimination and Employment Act of 1967 protects workers who are 40 years old or older from being treated unfairly because of their age. It stops employers from doing things like refusing to hire you, firing you, or treating you differently at work just because of your age. Now, how do you know if what's happening to you is age discrimination? Here are some common examples: exclusion from meetings, opportunities, or training programs, offensive jokes or remarks about aging or seniors, being replaced by someone younger who is less qualified, a pattern of older employees being treated worse than younger ones, such as layoffs or demotions targeting workers over 40, someone at work saying things like, "You're too old for this," or "When are you going to retire?" You're getting bad performance reviews or warnings even though your work hasn't changed, and younger employees with less experience are getting promotions or better assignments. I want to focus on protections against retaliation. If you speak up about age discrimination, the law says your employer can't punish you for it. If they do, you could have a separate claim for retaliation in addition to your claim for discrimination. Retaliation claims are often the strongest part of an employment case because they're sometimes easier to prove than the discrimination itself. In fact, your employer can still be held responsible for retaliation even if you don't win your discrimination claim. This means they can't demote you, fire you, or exclude you from important opportunities because you reported discrimination. Sometimes, though, employers break this rule. If they do, it could actually help your case. For example, if your employer removes you from key projects after you complain, this shows they are trying to silence you. These actions are often clear proof of retaliation. So what can you do to build your case if you're still employed? If you think you're being treated unfairly because of your age, an employment lawyer can help you take steps to protect yourself, such as helping you collect and save emails, performance reviews, and notes about what's happening, working with you to write down dates, details of events, showing you how to label your notes for my attorney or in anticipation of litigation so that it is clear that those notes are private, looking for patterns of how other older workers are treated, helping you write complaints to protect yourself under the law and prepare for a retaliation claim if needed, helping you follow your company's rules for reporting discrimination, and preparing you for investigations or meetings about your complaints. If you win your case, here's what you might be able to get: pay for the time you couldn't work because of what your employer did, money for the paychecks you would have earned if you hadn't been fired, compensation for the stress and emotional toll of being treated unfairly, extra money if your employer broke the law on purpose, and payment for attorney's fees and legal costs. A lawyer can make a big difference in your case. Here's how they can help. They can write a formal complaint for you and make sure that it's done in the right way. They can give you advice on how to talk to your employer or HR without hurting your case. They know the law inside and out, so they can find extra protections you might not know about. If your case goes to court, they'll help you gather evidence you need to win. This includes requesting emails, hiring documents, text messages, and other documents from your employer, as well as conducting interviews with witnesses to uncover key facts and patterns of unfair treatment. Let's talk about now statutes of limitations. There's a deadline to taking action. Usually you have between 180 and 300 days to file a legal action, depending on where you live. Don't wait too long. If you miss a deadline, you might lose your chance to stand up for your rights. Now you know the signs of age discrimination and how the law can protect you. Think about Dr. Claire Hanley and how she stood up to her employer after facing unfair treatment because of her age. Her courage and willingness to fight back shows that you can do it too. If you think this is happening to you, don't wait. Take action. Reach out to an experienced employment lawyer to talk about your situation. If you click on the link below to schedule a free consultation, we'll be happy to speak with you. And the sooner you act, the better your chances for protecting your rights and for getting a substantial and quick result.